fees. And that's with the cheapest, worst lawyers on the planet. Can you imagine spending $50 million on the people who just lost you $83 million?
The Supreme Court is scheduled to hear arguments this week in the appeal of the Colorado High Court's decision that former President Trump is ineligible to run for president because of the January 6th insurrection. The Colorado court cited the Constitution's 14th Amendment that bars anyone who took an oath as an officer of the United States and then engaged in insurrection from ever holding office again. The Supreme Court's decision is likely to be the most consequential election ruling since Bush v. Gore more than 2 decades ago. Also this week, the final verdict in former President Trump's New York civil business fraud trial could come. The decision had originally been scheduled for release at the end of last month, but the judge delayed the ruling. The judge presiding in the case has already ruled the Trump Organization has committed fraud. The verdict will determine penalties and resolve other claims of wrongdoing from the case. And joining us now is former litigator and MSNBC legal analyst Lisa Rubin. Lisa, let's start there. What is causing the delay? I understand there was a letter from the judge that is a monitor in charge of Trump's businesses, and there's a whole bunch of incomplete information that judge is dealing with. How does that impact the decision Judge Engoron has to make?
You know, Mika, we don't know for sure whether the letter that you're referring to from retired Judge Barbara Jones, who is the monitor in the case, is impacting Judge Engoron's decision and its timing. However, as you noted, it's a 12-page letter that points to lots of improprieties in the Trump's financial statements. One of the things that it points to, and maybe the thing that's most troubling about it, is for years it's been understood that one of the business entities in the Trump Organization loaned former President Trump personally $48 million. According to Judge Jones, in a footnote in this letter, she could never find, no matter how many times she asked, documentation of that loan, and was later told essentially that the loan didn't exist. The Trump Organization lawyers, they refute that. They say the loan did exist, and what we did was give Judge Jones an intra-company memo telling her that debt had been extinguished. But I've looked at that memo. Memo is from December of 2023. It's a memo to the file, so nobody even had the guts to sign it, essentially. And it just says that the debt has been extinguished. There is still, to this day, no documentation that the loan existed. And you might be thinking to yourself, well, what's the big deal about that? The big deal is if that loan did not exist and it was instead a gift, there would be massive tax consequences to that, as well as some improprieties in the financial reporting that went to Trump's financial institutions and insurance companies. In essence, a continuation of that same fraud that's been going on for years and has been showing up in his financial disclosures as a candidate. You'll remember that as president, for example, Donald Trump filed these presidential disclosures where we could see all of his finances. He is required to do that as a declared candidate as well, and the loan showed up in his most recent disclosure as of April 2023. So as, you know, they would say on I Love Lucy, someone's got some explaining to do.
So I want to ask you about Colorado, but I just a little bit more on this. If the monitor has uncovered questions of more fraud, to put it carefully. Okay, so that's one thing, but doesn't that also just play right into Donald Trump's constant narrative in any of these cases, which is delay, delay, delay? What happens to the timing of the decision as they're trying to figure this loan out or whatever it was?
You know, I don't think it will have much of an impact on the decision. You'll remember Judge Engoron promised that he would try to have a decision by January 31st. Last week, the Office of Court Administration released a statement saying we should now expect that decision by early to mid-February. So I think it maybe pushes it out a week as the judge adds this to the pile of evidence that he once said could fill an entire room of the Trump Organization and Donald Trump's own fraud. But we're not talking about weeks, plural, Mia, or even months.
So, Lisa, was noted, this is a big week, the Colorado case coming before the Supreme Court. As Mika said, perhaps the most consequential electoral matter it's heard since 2000. So walk us through what you expect us to hear. What will the outcome here be?
I think let's start with the outcome. I think the outcome is going to be that the court does not disqualify Donald Trump from being on presidential primary ballots. How it gets there, of course, John, is another story. One of the things that I expect that we'll hear at oral argument, and one of the things that puts a chill into me personally as a lawyer, is something that Donald Trump's team put on the very last pages of their brief. It's been long presumed that when a state Supreme Court makes a factual finding, that the United States Supreme Court is supposed to defer to that. They really can't mess with the factual findings of a state Supreme Court. However, Jonathan Mitchell, who's Donald Trump's lawyer here, essentially says there's no reason for the court to give any deference to that, and they should feel free to disturb the factual findings and sort of revisit the question of whether Trump participated in an insurrection at all. In this case, that would have big consequences, but overall, in terms of Supreme Court jurisprudence, that would have huge consequences. If a state Supreme Court is no longer the final arbiter of its own facts and law, you can see how that would topple basically the system of state to federal appeals as we currently understand it.
All right. And finally, this for you, Lisa. Fulton County District Attorney Fani Willis is acknowledging for the first time having a personal relationship with Special Prosecutor Nathan Wade. The revelation came on Friday in a 176-page filing, and in it, Willis's team argued the relationship did not result in any, quote, disqualifying conflict of interest. Election interference co-defendant Michael Roman, who first made the allegation of an improper relationship, is attempting to use it to have his charges dismissed. Former President Trump has joined that effort. There is an evidentiary hearing on the allegations scheduled for next week. Lisa, what do you make of all of this?
Mika, in a word, it's tawdry. And I don't think it really has much impact on whether Fani Willis should be disqualified, because at the end of the day, the things here that are troubling, and I want to be clear with our viewers, there are some things here about this that are troubling to me. In particular, the fact that Nathan Wade doesn't really have a background in RICO law. On the other hand, if you take Fani Willis at her word that no relationship developed between the two of them until after his appointment, and you take her at her word that these are two financially independent people who, in the course of one of their divorces, ended up in a relationship with one another, there really is no there. It is just a distraction that is needlessly consuming time. And as you noted earlier, the name of the game with Donald Trump always in litigation is delay, delay, delay.
But, I mean, obviously, you brought it up. It begs the question, why in the world, in a complex RICO case, the most important that not only she would ever try, but that probably any state would ever try against a politician, she would appoint somebody who has no experience in RICO law?
Well, Joe, let me play devil's advocate with you for a second. There are two other special prosecutors here, one of whom, John Floyd, is very experienced in RICO law and was appointed specifically for that reason. Fani Willis would say that she appointed Nathan Wade here because she knew him to be an effective leader of teams, that he is effectively the quarterback of this team, coordinating all other resources and generally serving as sort of the strategic captain here. If that's the case, that makes more sense. But again, there are some judgment calls here that are probably not the best, not making everybody here smell good. The optics are bad, even if legally they're on solid ground.
Former litigator and MSNBC legal analyst Lisa Rubin, we will see you many times this week. Thank you very much for starting us off this morning. And coming up, despite a growing economy and little opposition